before the break. Ken asked another great question. If you will, just briefly repeat that for us.
Yeah, so Keith, if you'll talk to the viewers a little bit about the importance of power of attorney, and especially as when you have elderly folks in your family and you want to make things more efficient and you want to guard against, I guess, a lot of confusion later on. Just talk with our viewers about that.
All right, what I tell everybody about a power of attorney.
And what is a power of attorney?
All right, a power of attorney is when you give another person the right to do all of the things that you could legally do yourself. You sign something to contract for it, you consent to medical care, you say I want this, I don't want this. Making legal decisions like that, you give another person that authority. It does not take any authority away from you, but it gives that person the joint authority. And it is just a crucial document to have in place, not only for elderly people, but for everybody. I tell people that the only reason why everybody does not need a power of attorney is that if there is no one on this earth that you trust to give that power to, you need a power of attorney. I'll also tell them right before they sign, I meet with them privately, if you don't trust this person, do not sign this document. Right? But it is a crucial document, because if there were to be something that occurred where a person was incapacitated, they were no longer able to sign a power of attorney, no longer able to make their own wishes known, then the family is going to have to go through the guardianship conservatorship process, which is going through court, tremendously, easily 20 times more expensive than getting a power of attorney. Takes 4 to 6 weeks. You got to post bond.
Wow.
You have to ask the court's permission to do a lot of things. You have to file reports back with the court. You can avoid all of that by a power of attorney, which generally just a few $100s will get you a power of attorney.
And how long will a power of attorney last?
A power of attorney will last until death. I've had some people come in, and we should be talking about an estate, but they're saying, oh, I can do so and so because I have a power of attorney. I go, well, not anymore, you don't, because all powers of attorney, every single one of them, it expires instantly at death without anybody having to do anything or take any action. All of them expire at death. We
were talking a few minutes ago, and I want you to talk about these things to our viewers, because I think they just need to know certain things. Let's say that somebody has a life insurance policy through their job, okay, or a life insurance policy.
Right.
All right, but they don't have a will, but they sign the beneficiary to, they name the beneficiary as whoever they name it to, their spouse or maybe their kids, something else. Okay, so how does not having a will affect that, or having a will?
Yeah.
How does that affect?
Well, it actually does the same thing whether you have a will or not, because when you have what we call a named beneficiary, which is where you have somebody's name, because you can just have on that insurance policy or your 401k payable to my estate.
Ah, okay.
But if you have the name of someone, that is going to pass outside the probate process. It is not going to be affected by anything that's in the will. It is never going to come into the probate court to where it's under the control of what the will says. So it's going to pass outside probate. It's actually one of the ways that people can do what they call avoiding probate, which sounds like a bad thing, but it's actually just a planning process that you go through.
All right, curveball.
All right.
We talked about earlier.
I was thinking that.
You get a divorce. Divorce says that whatever you had in the will before, if you had your ex-spouse now that you have got an order from the court, says y'all are busted up, they're technically off the will, right?
Right.
But what about that life insurance policy? And they're a named beneficiary.
If they're a named beneficiary, that is a contractual agreement, and it is going to have to be changed, or else it is going to remain in effect.
Okay.